Hello, welcome to the Consultation. My name is Josh Floyd.
And I'm Christina Jimenez.
We are both board certified family law attorneys here in the state of Texas, both attorneys at Jimenez Floyd Family Law Firm. We have offices in Flower Mound, Louisville, Dallas, Midland, Odessa, Bedford. Is that all of them?
I think that's...
Oh, got them. Okay. So if you need a family law attorney in those areas, reach out to us. Today we are going to discuss, what actually happens at a temporary hearing.
That is correct. I always explain, I don't know if you do this, Floyd, but whenever a client comes in, either for a consultation or after they retain us, I always kind of say there's a few main events that are going to happen in your case. And the first is obviously we have to file. The second is typically a temporary hearing. The third is normally mediation. And then the last is a contested final trial if you can't settle at mediation. And in between there, you'll likely have some discovery that takes place depending on the complexity of your case. But those are kind of the four main ones. So the temporary orders hearing, in my opinion, is probably the most important hearing that you're going to attend because it kind of sets the expectations for the entire case. And I think a lot of attorneys kind of take that for granted. And I think a lot of clients don't really understand the significance because I have had a ton of attorneys who kind of just show up and they're not prepared for that setting. And that's just never a good idea. And so, go ahead, Luke.
We've had many clients that came over to us and be like, well, they told us it was just a temporary hearing, so agree to this.
Right.
Right. And we obviously don't feel that way.
Right. So explain what temporary orders are, Floyd.
So I explain it kind of like a Band-Aid, right? Or an opportunity for the court to stabilize what's going on in you guys' situation at that point.
You guys's?
Right? You guys's? That's
I
legal term. They just added that to the Black's Law Dictionary.
Okay, very good.
In your situation, right? So it'll outline, where the kids are going to live, what visitation looks like, child support issues, any other additional injunctions or stuff we need related to children, but also in a realm of divorce, who gets to use what property, who's paying what debts, spousal support if it's needed, attorney's fees if it's needed, that kind of situation. So kind of just puts a Band-Aid on it to make sure that there's no craziness going on between that time and the time we're able to get ready for final, because it does take a lot more time to get ready for final.
Right. So in the state of Texas, there's a minimum waiting period of 60 days. Okay.
It's a divorce context, right?
Right.
Okay.
Sorry. Thank you. In the context of a divorce, in the context of a custody dispute, there's not a set, what's the word I'm looking for?
Waiting period.
Waiting period. Thank you. And so in theory, you could get it finalized within, 30 days, 20 days, especially if you guys have an agreement. I will tell you that in most of our cases, it's probably going to take you about 6 months or longer to finalize your case. Some of that has to do with the attorneys, right? Some of it has to do with the work that needs to be done. Most of it really has to do with the court system and the fact that these judges are carrying very large dockets. And it just takes time. There's just not enough time to squeeze in all of the contested cases. And so
some of that's parties' behaviors.
Yep. Some of it is, clients saying, hey, we want to reconcile. No, we're not going to reconcile. Sometimes clients do things that are really bad that now we have to give ourselves some more time because we're going to try to remedy, whatever situation they found themselves in. Lots of different factors can kind of come into play. We've had attorneys that have been ill before. We've had clients and opposing parties who have been ill before. We've had things going on with kiddos that, maybe they need to get in therapy. So now we have to wait. We have had complex property issues where maybe we're waiting on some tax consequences or business valuations. All sorts of things can make this time extend beyond probably what most of you guys are going to want. And so that is why the temporary orders are so important, right? Because then this is where the judge is going to say, in the meantime, this is what everybody's doing. Okay. And so let's kind of break it down. And I'm kind of thinking about this in the context of divorce because we do want to cover like property and we do want to cover child custody. And so at a temporary hearing, as it pertains to child custody, you gave like a brief overview of it, but explain typically like, conservatorship, possession, access, child support, all of the stuff, like how the court would typically render all that.
You asking what the ruling would be, or you asking what they would look at to determine?
I guess my chair's about to break underneath me.
Please let that happen.
Well, so I guess like the court's going to typically look at joint managing conservatorship or sole managing.
Right. Yes.
Right. If we should have a standard possession order. How about I just talk about?
Sounds like you're doing a great job. Yeah. Yeah.
Thank you.
You explain what you mean. Yes.
Today. Okay, I'll do it. This is why we shouldn't record in afternoons. We do better in the mornings. Is the court going to order a standard possession order? Are they going to deviate from the standard possession order, right? We're going to do a week on, week off. Is there some basis to potentially do supervised possession and access? And I'm going to stop there because that's kind of a big one, right? Where if you're going to deviate from the standard possession order, you need to be able to have evidence to deviate from that, right? And if you're just rushing into a hearing without having adequately prepared, and I guess we'll get that in the next section, then
it's not uncommon for you to jump ahead.
I know. Then you get stuck with your standard possession order. The judge is going to render child support. Right? Judge is going to look at injunctions. Like, are the new boyfriends and girlfriends going to be able to be around the kiddos? Can other family members be around the kiddos? Are we going to allow drinking? Are we going to allow, what else?
Co-parenting apps like Our Family Wizard, extracurricular activity issues, electronic communication when the children are at the other parent's house.
Airline provisions if you guys are living, in different states. Passport and international travel provisions if you guys, have the ability to go and, fly out of the country for holidays. All sorts of stuff. And so again, this isn't something that we're going to just rush into because we need to really kind of sit down and think about at a temporary hearing, are these orders going to be necessary? Or, is this just going to be a plain old vanilla, custody arrangement and we don't need to get all worked up over stuff? On the property side of it, do you now know like what I'm trying to get at when we're looking at property?
Yeah, so I assume basically you just want me to say that they're going to award, temporary exclusive use, like who gets to stay in the house, who has to pay the mortgage, who gets to use the F-150 versus the 1973 Suburban, right? And who's going to make those payments and the insurance payments. Medical insurance comes in play in divorces, right? Whether the spouse is going to be ordered to maintain the other spouse on medical insurance. Credit card debts, any type of debts like that, who's going to be responsible. And then, of course, temporary spousal support, right? If one party's been the primary breadwinner, the other party doesn't have the money to make their ends meet, right? Then we can get temporary spousal support along with that attorney's fees, right? If it's necessary, interim attorney's fees. Does that hit where you're going?
And what about businesses, Floyd? We have a lot of clients who own businesses.
Businesses are huge, right? Who's going to operate the business? What access is the other party going to have to those records, bank statements or QuickBooks records or whatever it is they use, so that money's not being funneled out and things like that. Yeah, so business is a big one,
right? And really kind of just laying down what we call standard mutual injunctions, right? So typically when the divorce is filed, there is going to be a temporary restraining order that either standing orders or temporary restraining orders that you're going to be served with. And so we always want to make sure that we incorporate those injunctions into the order because we want that to be valid throughout the pendency of the suit. And if you're in a county where there are standing orders, then it'll automatically be in effect once you're served and continue by its own or on its own. But if you're not, then we have to make sure that we incorporate that. And that's just so that people are not destroying property. They're not running up credit card expenses on trips to Vegas. They're not harassing, threatening. There's all sorts of rules that would come into play with those TROs. And we have another video on that if you're interested in that. So we're okay, don't worry.
The air conditioner came on, good.
And so I think that's kind of it as far as the purpose of the temporary orders.
Well, I always like to look at it also as, and I think this is one thing that sets us apart, is our ability to strategize, right? So we get your end game and we figure out how to get you there. We may find out at a temporary orders hearing that our strategy isn't what we thought it was going to be, right? And we have to shift gears. Or the judge played well to our strategy and we're on the right track, right? But it kind of tells us, like, hey, we need to shift gears or we're going the right path, right? And so I always tell clients after the temporary hearing, we'll get back together and revisit our strategies, how the judge thought about it, how the judge ruled on our stuff that we were presenting, right? And then determine from there, are we on the right track or do we need to deviate and go a different way?
Well, and like kind of going to that, how many times do we have a client who either in the consultation or after they hire us, we start talking to them about certain things and then we're like, yeah, we actually can't move forward at this point. Like, I understand that maybe you're not able to see your kiddos right now. I understand that maybe they're running up expenses, but there's something strategically that is taking place that we actually have to pump the brakes on requesting a temporary orders hearing, because if we have it, it's actually not going to be great for you, right? And I think that there are a lot of attorneys out there that as soon as they hire, they want to go in and they want to process all the paperwork and get it filed and they're going to set it for a hearing. And they're not really thinking about, wait, how is all of this stuff going to play out, right? And what is, 6 months down the road, 2 years down the road, how is this going to potentially hurt me? I actually did a consultation the other day where he had hired an attorney on an enforcement, and the attorney was like, cool, yeah, took the money, hired the enforcement. And the attorney didn't stop. And I don't know if he didn't think about it or if he didn't talk. I know he didn't talk to the client about it, but to say, okay, what's the consequence if I file this enforcement? Are they going to file a modification? Are they going to request a temporary hearing? Are they going to request a drug screen? Is my client going to get supervised access? And all of that stuff played out exactly the way, if we had done the consultation, we would have said, you can't move forward with your enforcement right now because you're going to have all of these potential issues. And so, just make sure that whatever attorney you're talking to, they're kind of looking at this stuff holistically, because otherwise you could find yourself in a bad spot. And a temporary order is not always going to be the best thing for you, right?
Agreed.
Okay. So pre-hearing preparation, um, document gathering, attorney preparation, etc. It's a lot.
It is a lot, right? And some attorneys don't take it as seriously, right? But for us, we're basically prepping for a final, right? And we are prepping because we know it sets the stage, right? It sets the very foundation for your case, and it's going to set a status quo. And so I think we put a lot more into it than most attorneys do, which is good for our clients. Um, but yeah, I mean, we're gathering, bank statements and stuff early on, right? So that we can prove what we need to prove. Whereas most attorneys will wait, well, that's a final hearing issue. That's a final hearing issue. Like, no, all of that is relevant at temporary because it helps determine our strategy.
Right.
Bank statements, text messages, photographs, financial information statements, pay stubs, tax returns.
Yeah, and so when you're the petitioner, and I guess that is one thing, like people always say, like, is there a benefit to being a petitioner as opposed to respondent? It kind of is a benefit if you're the petitioner, because you can control when you file and when you request your temporary hearing, right? And so there have been several cases where I start talking to the clients and I'm like, wait a minute, like I'm going to need spreadsheets on this. I am going to need you to get me all of the text messages, and they're going to be 2,000 pages. So I'm going to need, more time to read through all these text messages. I'm going to need you to get me different videos and different recordings, etc. And so I decide this is not ready for temporary. We're going to postpone it, and then we're going to get this stuff, and then we'll be ready to go. Right. Now, if you're the respondent, that's kind of crappy because sometimes it gets set for a hearing. And I actually just had this happen to me the other day where we were hired. And I think it was about 10 days before the temporary hearing. And I was pretty confident that I was going to get my continuance. And I didn't. And so I had 10 days to prepare a crap ton of evidence for that temporary hearing. And thankfully it went really well. But sometimes it doesn't go that way. And that's scary. So I would say And we always do this. I don't know if a lot of attorneys do it, but we always have what we call an initial client meeting, right? And that's whenever you hire, we discuss case strategy and we start prepping you for gather this document, gather this document. Here's, how all of this stuff is going to go down. Listen to your attorneys and get the evidence that they need, because we're going to need it at the temporary hearing. And if you have it all organized for it, it's going to save you a ton of money and you're probably going to be more successful. So at temporary hearings, as it pertains to custody, what are some of the things that you're typically looking for?
Like conservatorship, possession, access, or all child issues.
Let's just do conservatorship and possession and access.
So we're looking for any history of drug use, criminal offenses, CPS reports, family violence stuff, involvement with the children's activities. Tardiness to school if one parent's responsible for taking them, grades,
text messages between the parties,
text messages, that would show any of that stuff. Photos if there's family violence, videos if there's cursing and
family violence, neglect, child neglect. We've had stuff like that happen.
Or just being ugly to the kids, right? I mean, talking down to the kids, calling them bad names. Unfortunately, we've seen some of that. So videos along those lines. Witnesses, right, that have seen it. Family, friends. If we can get the other parties' family, that's fantastic. It doesn't happen very often, but it's always gold when we get it. So any witnesses that have seen any of this stuff transpire. I
feel like that's mostly it. Like coaches, teachers, those are good witnesses. I feel like you got most of it.
Yeah, and even if you don't have those issues, I always get photos. I tell my clients, give me 5 to 8 to 10 photos that would depict your relationship with the children, right? Because we want to turn these children into people in the judge's eyes and not just a cause number. And so always, give me the 8 to 10 best photos that depict your relationship with the children so that we can show the judge, a picture's worth 1,000 words.
Right.
And so we like to show the judge, this is the type of relationship my client has with the kids.
Right. And so as it pertains to child support, what are we looking for?
Bank statements, W-2s, pay stubs,
tax returns.
You'll
want to make sure that your attorney does a child support calculation, present it to the court.
Cost of medical insurance, dental insurance for the kids.
Yeah, and I always do, like, if I know that custody is going to be a dispute, I'll typically do one for my client and for the other client just in case I lose, because I don't want the other attorney setting this outrageous child support number. I'm going to have my calculations prepared for the court, so I would say go ahead and do that.
And child support is the one area where I will tell clients, that may have to wait because I can't prove his income right now, right? Because we may have pay stubs showing he's making X, but we know that he's working under the table or doing something else somewhere else. And in order to prove that, I have to get documents from the other side, which takes time. And so at the temporary hearing, it may be set lower than what I'm aiming for at final until I can get those documents. And then at final, I'll go in and prove his additional income to get the additional support.
Or sometimes we'll file a motion to modify the temporary orders. And that's always my favorite, is whenever somebody lies on the witness stand about their earnings, and then I do my discovery or I subpoena third parties and I get my income information. And then I go back to court in a couple months and say, hey, judge, here's what he told you. And now here's what he actually has. So that doesn't ever work out well for the other side. So don't do that. Just be honest, because we're going to figure it out, or the other side's going to figure it out. And you don't want to get caught lying to a judge. It never goes over well.
It's not worth the little bit of money you're going to save.
Right.
Crazy.
So that's child support. We don't need to worry about the injunctions. When it comes to property, let's talk about marital residence. If there are children, who is probably going to keep the marital residence?
The person that is awarded the children.
Right. And so we see that a lot, right? Where somebody's just fighting for custody of the kiddos because they want to be able to stay in the house, and or they don't want to pay child support, and or they don't want to pay spousal support. And so going back to the documents that Floyd was talking about, like the school records and the medical records and the text messages where we're showing, listen, hypothetically speaking, mom has always been the primary caregiver, and now dad's just trying to fight because he doesn't want to do all these other things. And so let me show you that. And then you're probably going to also win temporary and exclusive use and possession of the home. Vehicles.
Whoever's been using them gets to keep using them usually.
Yeah, don't like this is one of my biggest pet peeves is whenever like mom's always had a car and dad's always had a car, and then all of a sudden mom's saying like, no, I want his car. It's a nicer car, and it's like we have bigger fish to fry. We're not going to waste time and money, and judge isn't going to give it to you. I mean, judge is going to say whoever's been driving this, just keep it.
Yeah, you've been just fine all this time. Like, you can get by.
Exactly. What else? Bank accounts. I mean, I guess the court
Adultery, if there's adultery,
Mhm.
right? We need any evidence you have of that.
Right. Well, and as it pertains to bank accounts, the judge is going to potentially say, you use this account, you use that account, we're going to split these funds up, or we're going to say that nobody can use this account. So just kind of be prepared for those arguments. What else on property? I think that's it as far as evidence is concerned.
Yeah, I think so.
Okay, easy breezy. So what actually happens in the courtroom? I feel like we could do a whole separate podcast on like presentation of evidence and how this stuff works.
Could be a lot.
So courtroom layout. Do we need to? I guess
why not? Right? I mean, these people haven't been in there a lot, right? Okay. So I'll tell you, the day of the temporary hearing varies depending on the court, right? Some of them have a docket call, and you'll have an 8:45 docket call, but your hearing may not be actually go until 2:00 in the afternoon, right? Some of them you're specially set for 9:00, and when you get there at 9:00, your hearing starts at 9:00, right? And so make sure you're asking your attorney how this court runs their temporary orders hearings. But once you get into the courtroom, right, you have you've seen them on, I guess, TV, right? You have the judge sitting up front, right? You have the court reporter there who just types down everything that's said. And you have the two counsel tables, right, which is where the attorneys and the clients will sit. You have the witness stand that's next to the judge generally. And then you have the bar and everybody behind the bar, which is what they call the gallery or the galley.
Galley.
Galley. Yeah, that's where everybody, all the, what do you call them? Spectators sit.
So this is a funny one. So announcements and stipulations. So typically the judge will say, counsel, announce yourself for the record. And I always stand up, and inevitably my client always is like this halfway, like they're standing up with me or not. Do you tell your clients to stand up with you?
No.
Or do you just, I'll always say, you can stay seated.
Yeah, sit down. This is my show. I'm trying to steal the
It's always this weird. It happens to me almost every show, but I need to start telling my clients, just sit down, you're good. But I'll always say, like, just tap them, like, you can stay down, you're good. But anyway, so announcements. I guess don't stand up when they say counsel state for the record. It's a good tip. And so we stand up and we say, this is who we are and this is who we represent, and then the other side will do the same. And then they'll typically ask for like preliminary matters or housekeeping matters, and the lawyers will kind of do their things and talk about different evidentiary issues and procedure issues, etc.
If there's any agreements, they'll be announced at that point.
And then judge says, okay, call your first witness. I got a little nervous when I said that. I still get nerves after 18 years. As I call your first witness, and then petitioner goes first, and they'll call whomever they want.
Typically, their client sometimes strategically will flip and call the other party, depending on what's going on in the case. But typically, their client, and they'll do what's called a direct examination, which is supposed to be open-ended questions: who, what, when, where, why, how questions. And they'll go through and present their case through their client using open-ended questions. And then they'll pass the witness.
And then when they pass the witness, the other attorney gets to conduct what we call cross-examination. And that is typically leading questions, right? And so it's basically a question that's going to prompt a yes or no response. That's the idea, right? Like, you went to the store on this day. You hit your wife with a broom, whatever it is, right? And I always tell my clients to listen to the question, count to 3 silent in your head when you listen to the question. Only answer the question. Do not extrapolate. If you do not understand the question, state you do not understand the question. Do not guess as to what they are asking you. Because I've had it happen so many times when these really smart attorneys use these really difficult words and my clients, yes. And I'm just like, you just admitted to hitting your wife. Did you know that that's what you said? And they're like, no, I didn't know that that's what that meant. So just say, I don't understand. Can you rephrase the question? If you truly don't know, just say, I don't know. It's okay to just be honest. Like, that's the idea of this whole thing, is just be honest. And so they'll ask cross-examination and they pass.
And then you have redirect, if there is a redirect, right? And this is supposed to be very limited. Unfortunately, a lot of attorneys don't make it so. But it should be very limited. A redirect, 2 or 3 questions in and out, address what you needed to address that you heard on cross. and then you pass again.
Yep. And you keep going back and forth like this until such time as everybody says no questions. Once that happens, then you basically call the petitioner calls their next witness, and then their next, and their next, until they do something that we call rest, right? When they rest, then that's when the respondent gets to get up and put on their case in chief. And so
same thing, right? The respondent calls their witness. A lot of times, all of it's been dealt with in the petitioner's what we call case in chief when they put on theirs, right? So if they were to call our client on in their case in chief, right, we may go ahead and ask our client questions to put on our case during that time, or we may hold our case for our case in chief and then call our client, put on our case, depending on the strategy. But yeah, so the respondent will call all of their witnesses or present their evidence in their case in chief, and then the respondent will rest.
The other thing that sometimes happens in this process is the judge will actually stop down and say, hold on, I have a few questions for you. And they get to ask you whatever they want to ask you. And sometimes, as the attorney, it's a little bit frustrating because sometimes they're asking questions that you're like, number one, you shouldn't be asking this question, judge. Or number two, this is actually really harmful to my case. Why are you asking this? Opposing counsel did not ask.
We escaped this line of questioning and you brought it up.
And so, but they're the judge, so we just get to sit there and smile. And when they do that, I always tell my clients, because this is something that drives me absolutely nuts, is like, judges here and they're like, sitting here and they're asking you questions. And then the client, when they're answering, they're still looking straight ahead and not looking at the judge and talking to the judge. So turn your little chair and look at the judge and talk to them and answer their questions. It's just a sign of respect, right? And so when they finish asking questions, then he'll say, do you guys have any questions? And I'm like, well, no, you just screwed up my case.
No,
so
not anymore.
I think I'm good. And then after that, respondent will typically rest. And then you can do closings sometimes, just depends. And then the judge will sometimes announce their rulings. And sometimes they will take something under advisement.
Which is annoying.
It is annoying because we're checking our email every 5 minutes to see when the ruling is going to come out. And basically what that means is they're going to think about it. They're going to look at some of the evidence. And then after that, they're going to send us all a letter. And in the letter, it's going to say what's going to happen to you and to your children and to your property. I understand why judges do it, because inevitably, if they do an oral rendition, the attorneys are going to stand up and say, well, judge, what about this? And why can't you do this? And I need clarification on that. And so they kind of get to evade the BS, right? They just put their stuff out there and then it's done. But
sometimes their orders are unclear and we need
clarification.
Yes.
Yeah. And so then we end up having to go back and file another motion, etc. So my preference is typically the oral rendition, because sometimes I do need to understand, okay, just so I'm clear, this is what you're ordering. And I typically, at this point in my career, don't argue with the oral rendition. There's going to be some judges that are looking at this like, that's not true. But typically I don't. I haven't found a whole lot of success in doing that. I just listen and ask for points of clarification, and then I'll sometimes say, will the court potentially consider doing this, right? Or, did the court take this into consideration when rendering this ruling? Sometimes they'll say, actually, no, that's a good point. And most of the time they say, yep.
I don't think that, actually, good point. I don't think that happens very often.
They tell me a good point all the time, actually. And so then they render their rulings, and it's a temporary order. And so can I appeal the temporary order, Mr. Floyd?
Negative. There's no appealing a temporary order.
And so you're stuck like Chuck, which is why it's so important to be prepared for it. So very important to be prepared for it. Because we have had clients, and unfortunately it happens a lot to us, where they hire a different attorney, they go to a temporary hearing, and they get this really, really, really crappy outcome. And then they come in and they say, well, now we want to hire you and we want you guys to go in and fix this. And unfortunately, at a temporary order, there's not a whole lot we can do, right? We have to look at some way to modify that temporary order, which means there has to be some sort of change in circumstance, which sometimes there is, sometimes there isn't.
Yeah, you don't get two bites at the apple just because you don't like the first attorney you chose, right? Or you feel like they didn't present the evidence correctly. that's the attorney you chose, and unfortunately, the judge is going to make you stick with that until, like I say, something else happens, right? If there's new events that occur, we can go back and try to relitigate some of that. But for the most part, you're stuck like Chuck. We're Chuck.
I know. Pobre. So, how judges make decisions?
Okay, flip a coin. God, I wish I knew sometimes.
Stop it. So, as it pertains to children, we're always looking at the best interest standard, right? And so, we're looking at stability. We're looking at past, possession, access, who's taking primary care.
Drug use, family violence, even adultery, to the extent that they're spending time with their paramour rather than with their children, or out drinking and stuff like that. Yeah.
And then as it pertains to child support and spousal maintenance and payment of household expenses and liabilities, they're looking at, who's the breadwinner, who has the financial stability, what expenses does each one of these parties have. That is something that we didn't talk about when it came to evidence, is a financial information statement. So if you need your spouse to help you, or if you know that the other spouse is going to request that you help them financially, you should always have a financial information statement to basically say, this is my income, these are all of my bills, I cannot afford to pay her, or this is how much he has to pay me because I can't afford my bills, right? So they'll look at all of that, and then they'll make a decision on spousal support. Ability to co-parent is a big one.
It's huge. Yeah, it's huge. Judges like co-parents. Judges dislike people that are unwilling to co-parent. And this they'll look at, basically from the time that you guys separated, right, until we get to the hearing. How have you guys been working together? Who's been the jerk? So use another word, but probably not appropriate. But who's been the jerk, right? Who's been uncooperative?
And I don't think it's just from separation on. I mean, I think even prior to separation, like, what have you guys been doing and saying? Like,
Yeah, yeah, but at that point, like, you're not separated, are you really co-parenting, or you're just residing together,
yeah, I guess that's true. I got you. Go
right?
ahead.
But so co-parenting, like, if one person's sick, is the other person taking care of the kids, or like tough, it's your time, you deal with it, right? Or I want to take the child to my sister's wedding. Like, no, screw you, it's my time, right? I mean, whether you're being jerks, and please don't be the jerk, right? At the end of the day, I mean, the judge is looking after the best interests of the children, and they want to know the parents are doing the same, right? And so that's where you win brownie points with the judge. Is I don't like this, but it's best for the kids for me to let them go to dad's house for a little bit, right? Because it's not about you.
Right.
So
So credibility is very, very huge on how judges make these decisions. And I have won cases because the other side lacked credibility, and I have lost cases because my client lacked credibility. And so, going back to what I said earlier, and that is just be honest, right? Because I think at the end of the day, um, judges will respect that and typically rule more favorably if you just own your BS, right? Like, I think most of these judges understand that almost everybody that's walking into their courtroom at some point is going to be walking in with some sort of unclean hands, right? And so it's better for you to own it, acknowledge it, beg for forgiveness, show that you're accountable and that you've learned and you've grown and you've changed, and then we move forward from it, right? But lying about it, you're never going to have success in any of that.
yeah, I tell all of my clients before a hearing, I'm like, look, I can fix almost anything that comes out, right? I can't fix your credibility. Like, once it's gone, it's gone.
Right. And so, judges are going to be looking at, um, I guess your appearance, right? How you look. I tell all my people Sunday best, right? Wear a full suit if you have one. Ladies dress very conservatively. Make sure that we're well groomed, that we present well, right? You're going to watch your tone in which you speak, right? We're going to, um, I've had clients who they're very, very angry at their situation, and sometimes rightfully so, but I tell them, like, you have a very aggressive tone about you, and the judge isn't going to care for that, so you need to pull that back a little bit and be more mild mannered, right? And so these are the types of conversations you need to be having with your lawyer, and you need to be thinking about while you're there, because she's sitting there or he's sitting there and he's just watching everything you're doing and everything you're saying, and they're judging you because they are judges and that's what they do. So be mindful of it. um so anything else on that topic?
No, I don't think so.
Okay. So common client misconceptions. Temporary orders mean I'm losing custody.
I mean, you might lose custody at temporary hearing.
Right? They're interim measures, right? My thought is, really, if you lose custody at a temporary hearing, it's going to be very difficult for you to get it back. So I don't know that that's really a misconception. Um,
Not impossible. You still have a final hearing, right? But
it's difficult, very difficult. So the judge will hear my whole story. Oh Lord.
no, please don't try to tell it either. The judge will not hear your whole story. The judge will hear whatever your story your attorney wants to tell the judge.
Well, but the other thing is the time limitations on these things.
That is true. That is true. So some courts is 45 minutes aside. Some courts are 20 minutes aside.
Some are 30.
Some are 30, right?
Yeah.
And so we don't have so much time to present so much evidence. I mean, I love when I have clients come in with 2,000 text messages and 8 witnesses. I'm like, look, I have 45 minutes to put this case on. Right. I can't use this, this, and this. We have to prioritize, pick the most important things, the big issues, and that's what we have to hit. There's no time for you to get on stand and talk a whole bunch.
And it's so frustrating for clients, and I feel so bad when I have to tell people, like, listen, because some of the stuff is really good. It's very, very persuasive. But if I don't have time to present it, then it's of no use to you. The next one is that they don't need actual evidence. They're just going to tell their story.
That's also false.
Yeah.
Unless the other person comes off really incredible. Not incredible, because that would be good.
Not credible.
Not credible. Isn't in the inverse to credible?
Know, but not credible.
Not credible.
Not incredible.
Okay. Not incredible. Not incredible. So if they lose their credibility with the court, right, then maybe you could just get by with just your word, right? But you usually say things and you have something to back it up, right? Some stuff you may not have exhibits for, you may not be able to prove, but anything that we try to present, he hit me, here's the evidence to show that that's what happened, right?
Right. So it's just temporary, so I can relax. It's a misconception.
That's a misconception.
Yeah.
I think we beat that.
Yeah. Dead horse. Okay. So after the rulings, I'm going to kind of fly through this, but we'll draft temporary orders. Judge will sign those. They're enforceable by contempt. So make sure you understand them and you follow them, because if not, you could potentially go to jail. Yeah, one of the big things is make sure that you comply with that temporary order from now until the final trial, because at the final trial, right, even if you won primary at the temporary, if you are not co-parenting, if you're not complying with possession and access, if you're the non-possessory conservator and you're not paying child support, you're not exercising your visitation, things can change at the final, and they can change drastically. So just be mindful, make sure you're following your orders and that you understand them.
Yeah, I agree.
Anything else that we can talk about?
I don't think that's temporary orders in a nutshell, I think.
I think so. So, as always, thank you guys for watching and listening. This is not to be construed as legal advice. If you find yourself in need of an attorney, find one in your area, consult with them, have them kind of walk you through the route of how to handle a temporary order. And make sure that you follow us on all social media platforms, TikTok, Instagram, Facebook, YouTube, all of the places. And if you need anybody, or need an attorney rather, in Flower Mound, Louisville, Midland, Odessa,
Bedford,
and
Dallas.
Thank you. And we're here to help you guys. Have a good day.